But to answer Jessica's question, I mean, I'm not mindful of looking back at a litigation budget, something I should do more, but something that goes a long way is keeping the carrier constantly communicated and updating them the way we update the clients. And I could think of one particular dispute over a bill that we had where it was something that should have settled very quickly. We entered into a settlement agreement, had to file a motion to enforce a settlement agreement. It dragged on. We didn't update the budget. Our bill was cut substantially. But then the carrier claims analyst went to bat for us because we had constantly been in communication about what was going on. So that may help resolve some of those disputes.
Now, very well said. We ranked these pet peeves within these categories based on the volume of response from all of you and from the other outside counsel that were surveyed. And the overwhelming volume of responses about pet peeves was with regard to this subject of communication. And your comments are really embedded within a number of these issues. We had, everyone saying, in-house counsel needs to do a better job, or in-house legal professionals need to do a better job of raising issues with outside counsel sooner rather than later. In-house personnel need to share ideas with outside counsel, particularly if the in-house person has expertise or has someone that has expertise on that issue. The conflicting carrier directives with when multiple carriers insure a loss is something that many of you raised. Not providing clear direction to outside counsel as to acceptable outcomes and objectives at an early phase of the project was one we saw several times. Lack of consistent handling by a carrier. I think this referred to a couple people raised the fact that they'll be dealing with multiple adjusters during the life of a case, and creates obvious issues. Holding back from outside counsel facts that in-house personnel have learned in the pre-suit inquiry obviously creates inefficiencies, and preventing outside counsel from talking to people, having the facts, or failing to communicate to outside counsel when they can or cannot speak with the non-attorney business people.